Hi, everybody, and welcome to Localism, the podcast that asks if we're putting our power in the right places. I'm your host and guy who thinks that those little candy marshmallows peeps that get served around Easter time are fucking disgusting bluntschli. In today's episode, How to Achieve Localism Part 1, Amending State Constitutions. A couple of housekeeping things at the top here. First, I'm hoping that today's episode sounds a little bit better audio-wise than past episodes have. I've tweaked the settings on my microphone a little bit and changed a couple of things in my recording software, so hopefully that the mixing is a little bit better this time. My voice doesn't sound quite so tinny, and the music isn't too much louder than my talking, because that was some feedback I'd gotten in past episodes. Hopefully what I've done now has rectified that a little bit. Second of all, hopefully you're going to be hearing this just a week or two after we posted our previous episode, which was the one about localism and Trump's supposed closure of the federal ed department. That episode came out after a 3-week gap, which was unacceptably long. I really don't want to let that happen again. My focus from now on is going to be trying to get a podcast episode out every 2 weeks or so, kind of doing a release schedule of a podcast episode releases 1 week, then a YouTube short releases the next week, and then the podcast episode the next week. So everything is being released on 2-week intervals, but you're getting a new piece of content every week. Okay, with that stuff out of the way, let's turn back to what the main focus is going to be for today. So the past couple of episodes have really been about contemporary political issues, stuff like why would a contemporary liberal want to support localism, or why would a contemporary conservative want to support localism? And then the last episode we did was an episode about Trump's actions towards the Ed Department and how I might view those actions if I was somebody that supported localism. I'm pretty pleased with how that episode came out. In that episode and the conservative/liberal cases for localism episodes, it was really useful to apply localist thought to contemporary issues, which makes all the stuff we've talked about have a bit more of a connection with the real world. That's important. The first decent chunk of episodes were about legal doctrines and judicial opinions and kind of made up concepts, so coming a little more down to earth was a much needed reprieve. However, I do want to get our heads back up in the clouds just a little bit. We're going to come back to real life current events soon enough. God knows we're all living through enough historical events for there always to be something to talk about through the lens of localism. But for now, I want to circle back to some of the more theoretical stuff that we were discussing a few episodes back. As a brief summary, we spent several episodes talking about how localism is all about giving significant authority to local governments and making local governance more directly democratic, thereby giving ordinary people like you and me more agency in politics and passing laws. This was going to require 2 vectors of change. First was to reform the actual procedures by which local government is operated, moving from the current small r Republican form of government to a more directly democratic one. And specifically, it would operate along something that I call proxy-based direct democracy, which is just a form of direct democracy where you could delegate your vote to someone else if you couldn't or didn't want to show up in person to cast it yourself. The second vector of change was altering how preemption, or the way we resolve conflicts of laws, works in order to give local laws and thus local governments more power. There are alternate models that could be pursued to achieve this. One is the absolute localist model, under which the entire pyramid of preemption is flipped upside down and local laws become the highest law in the land, winning out over any contrary state or federal laws. The other is the reformist localist model, which is a little bit more complicated, but basically involves creating state-level 10th Amendment equivalents that say state governments can only exercise those powers explicitly delegated to them in state constitutions, and that any powers not delegated in such a manner instead remain with local governments. The reformist model also involves making this rather large carve-out of matters of local concern, where so long as a local government is legislating within those matters of local concern, state governments can't preempt those laws. This borrows from the concept of home rule that we talked about in an early episode, but this version of matters of local concern is much broader than the one used in home rule and will give local governments much more authority to legislate without being preempted by the state. Whew, okay, got all that? We've got prior episodes on each of these topics, so feel free to check them out if any of these ideas seem interesting. But no matter how you may feel about these proposals, I've certainly got friends and family who are skeptical about some or all of them. One thing we can at least all agree on is that proxy-based direct democracy in both of either the absolute or reformist localist models would be super different than how things currently operate in America at the state and local levels. So different, in fact, that they would require significant changes to our current laws in order to realize them. Thus far, I've been a bit hazy on what exactly those changes would need to be and what processes would be necessary to accomplish them. Well, that's what today's episode and the next two episodes are going to be all about. The details surrounding the methods of legal reform that we need to pursue in order to make localism a reality. First up on the list is amending state constitutions. And hey, even if you're not really into all this crazy talk about localism, you might still be interested in learning a bit more about how state constitutions work, why you should care about them, and how you might change yours. Let's jump in. So to start off, let's explain why amending state constitutions is even necessary in order to achieve local direct democracy and the absolute or reformist models of localism. State constitutions are the documents that set out the relationship between state and local governments. They do other stuff too, but that's one of the things that all state constitutions do. Say, this is the kind of control that state governments are going to have over local governments, and here's how you create local governments. Localist reforms are exactly aimed at altering that relationship. As a result, without amending state constitutions, local governments won't be able to make the changes to their charters necessary to implement direct democracy, and without the addition of a provision that says state laws are now fully preempted by local laws, which you would need in order to achieve the absolutist model of localism, or are preempted by local laws concerning the broad category of matters of local concern, as under the reformist model of localism, you're not going to be able to change the way that the relationship between state and local government works, and so you won't be able to realize these two localist models. And there's not a single state constitution that has anything like the state-level mini 10th Amendment that I propose be a part of the reformist model, which means we're going to need to add that provision to state constitutions via amendments too, if that's the route we're interested in pursuing. So in addition to the other legal changes that might need to be done, we are definitely going to have to amend state constitutions for both the absolute and the reformist model of localism, and if we want to make the procedures that our local governments operate by be something close to direct democracy. Now, before we get into how amending state constitutions works, I want to take a few minutes to consider what is a state constitution? What does it do? Why does it exist? Now, most of us are familiar or more familiar with the federal Constitution, the charter of government for the United States of America, our country. The federal Constitution sets out stuff like we have a president, and we have a bicameral federal Congress, and governmental power is split between the executive, legislative, and judicial branches of government. The federal Constitution also has the Federal Bill of Rights, which includes such certified hood classics as the First Amendment, freedom of speech, and the Second Amendment, right to bear arms. Less well known, or at least less commonly talked about, is the fact that in addition to the federal constitution, each state has its own individual state constitution as well. Just like the federal constitution, these state constitutions provide for the structure of a state's government and outline legal rights of state citizens or residents. For example, consider Article 3, Section 1 of the Nebraska State Constitution, which provides for Nebraska's famous and unique unicameral state legislature by declaring, quote, "The legislative authority of the state shall be vested in a legislature consisting of one chamber." Consider also Article 1, Section 8A-O of the Nevada State Constitution, which provides a victim of crime the right, quote, "to have the safety of the victim's family, and the general public considered before any parole or other post-judgment release decision is made regarding the relevant criminal." State constitutional law is a really fascinating field. It tends to get overshadowed a bit by the more flashy and more universally applicable field of federal constitutional law. After all, the federal constitution applies to everyone, but your state constitution only applies to you and other state residents. But in my totally biased opinion, biased because I just spent a bunch of time researching and writing for this episode all about state constitutions, state constitutions deserve just as much attention as their more famous federal brother. Here's a couple of reasons why. For one, state constitutions tend to be a lot longer than the federal constitution. That's because while the federal constitution is focused on how to create sort of a framework of relationships between the states, kind of like an overarching federal body that doesn't have to fill in all the details, in fact, explicitly doesn't fill in all the details, leaves a lot of the day-to-day of governing to the states to decide for themselves. The state constitutions have to address a lot of questions and a lot of fields that the federal Constitution either doesn't or can't. Another reason state constitutions are so interesting is just because there's a ton of them. Every state in America has a constitution. And that means that if you look through them, you can find inspiring, fascinating, or just plain wacky shit in state constitutions. For something inspiring, consider Article 2, Section 3 of the Montana State Constitution, which provides several rights that are similar to those in the federal constitution and other state constitutions, but also provides the far more unique right to, quote, a clean and healthful environment. That's right, Montana, not exactly known for its tree-hugging hippies, extends to its state citizens a state constitutional right to environmental protection. And this right is more than just hypothetical. In the 2024 Montana State Supreme Court case, Held versus Montana, a group of climate activists successfully sued the state and got the state Supreme Court to declare that certain state statutes preventing analysis of emissions and environmental impact statements were unconstitutional. The court relied on Article 2, Section 3 of the Montana State Constitution, and specifically the right it provides to a clean and healthful environment, to strike down the statutes. Montana Chief Justice Mike McGrath, who, to be clear, is a Democrat, wrote that, quote, the framers of the Montana Constitution intended it to contain the strongest environmental protection provision found in any state constitution that is both anticipatory and preventative. If you're a soy boy lefty like me, this obviously kicks ass. And even if you're on the right, you gotta admire the gumption of a bunch of kids to take on the state and win based on a constitutional right. Not to proselytize, but the fact that this is in Montana's constitution is also a reminder that preserving and protecting our country's national beauty was not always a left versus right issue. Some of the greatest conservationists in history have been staunch conservatives. Anyway, I gotta sneak in a little lefty propaganda in every episode, so consider this starting to meet my quota. Don't worry, there's more coming later, too. For a purely just interesting piece of state constitutional law, consider Article 2, Section 9 of the Colorado Constitution, the majority of which is about defining what constitutes treason, but the very last sentence of which reads, quote, the estates of such persons as may destroy their own lives shall descend or vest as in cases of natural death. In other words, people who commit suicide, their property gets handed out to their chosen heirs in the same way as if they hadn't committed suicide. I have no idea why this section of the state constitution that deals overall with the concept of treason then jumps over to how to deal with the property of people who have tragically committed suicide. Nor do I know why this topic was singled out to be handled in the state constitution rather than just have the state legislature pass a law about it or something. If any of you out there are experts on the Colorado Constitution or know something about this, please do drop me a line and tell me what's going on. Finally, for what I think is the simply goofy, consider Article 3, Section 47B of the Texas State Constitution, which sets out in painstaking detail how it is illegal for bingos, like the game bingo, to be conducted on a for-profit basis. More than that, before you can even start having bingo games be conducted by the few nonprofit or governmental or religious organizations that are allowed to hold them, you have to get the citizenry as a whole within a locality to allow it. A law enacted that allows bingo must, quote, permit the qualified voters of any county, justice, precinct, or incorporated city or town to determine from time to time by a majority vote of the qualified voters voting on the question at an election whether bingo games may be held in the county, justice precinct, or city or town. Like, obviously this is very funny because it's hilarious that a conservative stronghold that's all about deregulation is so strict about regulating bingo specifically that it's literally talked about in the state constitution. But it's also just kind of baffling. Who was playing bingo so much in Texas that y'all needed a damn constitutional provision about it? As of the 2020 census, Texas had the second youngest median age in the nation, behind only Utah and D.C. if it was a state. So is grandma getting a little too wild with bingo or something? Needed to make sure that everyone gets a chance to vote on whether or not she can go on her wild bingo nights with her lady friends? Joking aside, it actually is pretty cool to see a state constitutional provision that's so focused on local consent and deciding things via local popular vote. If only that kind of agency extended beyond whether grandma and her gal pals can have a fun night out. So, yeah, that's basically what state constitutions are. They are the mini charters of government that cover states in the same way, or at least a similar way, that the larger charter of government covers the nation, the collection of states that we call America. State constitutions tend to be bigger and longer than the federal constitution, and because there's 50 of the damn things, they're very diverse when compared to one another and occasionally contain some wacky, strange stuff. This framework of understanding is an effective way to approach the question of how state constitutions work when it comes to changing themselves. That is, how state constitutions work when it comes to amending state constitutions. Like the federal constitution, all state constitutions have provisions that explain how the amendment process works. Like state constitutions as a whole, there is some standardization between how state constitutions allow for amendments. And also, like state constitutions as a whole, these provided for methods can also be kind of diverse and varied and can sometimes involve odd or unusual ways of thinking about the problem of amendment, or just odd and unusual stuff in general. Now, to be clear, I'm not going to look at literally every single state constitution out there and give precise details on what each one requires for state amendments. That would require like a 10-hour episode. Instead, I'm going to try and point out a few generalities that tend to apply when it comes to state constitution provisions about amendments, and then go on to consider what I hope will be a mostly representative sample of state constitutions. This representative sample will be comprised of the state constitutions of California, New York, Texas, and Alaska. So basically, 2 liberal and 2 conservative states, and states that tend to be pretty unique when it comes to their laws. Okay, so starting with some similarities you might see in a lot of state constitutions. This might seem self-evident, but pretty much every state constitution acknowledges that the state's legitimacy comes from the people, and because of that, the people retain the right to modify the form of government as they seem fit. Massachusetts' state constitution has what I think is a pretty standard provision at Article 7, quote, "Government is instituted for the common good, for the protection, safety, prosperity, and happiness of the people, and not for the profit, honor, or private interest of any one man, family, or class of men. Therefore, the people alone have an incontestable, unalienable, and indefeasible right to institute government, and to reform, alter, or totally change the same when their protection, safety, prosperity, and happiness require it." This and other similar provisions in other state constitutions don't actually say anything about the processes that people need to observe to reform, alter, or totally change the state government via amending the state constitution. But it does acknowledge the right of state citizens to shape state government as they see fit. Most state constitutions contain a similar acknowledgement, which, if you think about it, is pretty amazing. A lot of the show has been about shitting on state government overreach and federal government overreach, but it is really cool to know that the average state constitution explicitly sets out that the state government derives its power from your consent and that you have the right to change the form of state government because of that fiat. Another thing you're going to see in a lot to most of state constitutions is that constitutional amendments are generally voted on via ballot-wide vote, not via just some vote in the state legislature. In other words, state constitutions consider amendments important enough to treat them as a separate kind of law. You're not going to be able to pass an amendment just by having your state representatives vote to approve in the state legislature. Instead, what's going to happen is usually the state legislature will have some way of proposing an amendment, but they can only propose it. And after they propose it, it gets put on the ballot for a statewide vote. And then, depending on how that statewide vote turns out, the amendment will either be accepted and made part of the state constitution if a majority of people vote for it to be accepted, or it'll be rejected. Thus, we have the following provision in Article 10, Section 1 of the Iowa State Constitution. Quote, "If the people shall approve and ratify such amendment or amendments by a majority of the electors qualified to vote for members of the General Assembly, voting thereon, such amendment or amendment shall become part of the Constitution of this state." Note that electors here doesn't mean like federal presidential election style electors. It just means people who have the right to vote in state elections, i.e. every state citizen. The point here is that most state constitutions are going to require you to convince a majority of your fellow citizens that your amendment is a good idea. You aren't just going to be able to play the insider game of politics with legislators in your state capital. You're actually going to have to approach the citizenry as a whole to tell them, hey, here's why I think the localist reforms that these amendments achieve are something that we should be pushing for. So those are the generalities. State constitutions reserve the right to the people to change their form of government via state constitutional amendment, and whether or not a proposed amendment passes turns on how people vote in a statewide election. Now let's jump into the nitty-gritty details of amending state constitutions by looking at our selective sample of states, starting, in no particular order, with the constitution of the tough, hardy, and self-sufficient citizens of Alaska. So to start off, Alaska does have that kind of common provision I talked about that is often in state constitutions, where a state constitution will recognize that political legitimacy originates from the people, and so the people have a right to change the form of government. Article 2, Section 2 of the Alaskan State Constitution, which is entitled Source of Government, says that, quote, All political power is inherent in the people. All government originates with the people, is founded upon their will only, and is instituted solely for the good of the people as a whole. Alaska then goes on to provide a dedicated article of the Constitution that is solely dedicated to how to amend it. Honestly, in my amateur opinion, the organization of the Alaska Constitution as a whole is really easy for someone like me who's dumb to navigate. Props to the drafters. Article lucky number 13 is the one that we care about because it's all about how to change the Constitution, and despite being a pretty short article overall, it has some really interesting stuff in it. So to start off with, unlike some other state constitutions, the Alaska Constitution does not allow state citizens to go around collecting signatures to try and get a proposed amendment on the ballot. The Alaska State Constitution makes very clear that there are only two ways to propose an amendment, and neither of those ways is to go around collecting petitions for an initiative or something. The first way to propose an amendment is by a supermajority vote of 2/3 of both houses of Alaska's state legislature. Now, what this means is that somebody in the state legislature introduces an amendment like it's any other law and says, hey, I think we should amend the Constitution to say this. Then both houses of Alaska state legislature will need to vote for it, and 2/3 of the people will need to support the idea, yeah, we should change this. We should add this amendment to the Constitution. But even if everybody agrees, that doesn't mean that the amendment then gets passed. Instead, all this does is allow the proposed amendment to get put on the ballot so that state citizens as a whole can then vote on whether to accept or reject it. This is pretty straightforward. But there is another way to initiate an amendment process in Alaska, one that is much more unusual. Article 13, Section 3 of the Alaskan State Constitution provides, quote, if during any 10-year period a constitutional convention has not been held, the lieutenant governor shall place on the ballot for the next general election the question, shall there be a constitutional convention? If a majority of the votes cast on the question are in the negative, the question need not be placed on the ballot until the end of the next 10-year period. If a majority of the votes cast on the question are in the affirmative, delegates of the convention shall be chosen at the next regular statewide election unless the legislature provides for the election of the delegates at a special election. So a lot to unpack here. This idea for a constitutional convention is probably inspired by one way that it is technically possible to amend the federal constitution, which is to call a constitutional convention after 2/3 of all state legislatures vote to do so. This method has never been used to amend the federal constitution, partially because it's incredibly damn difficult to get 2/3 of all the states to agree about anything. As it happens, this method of putting on the ballot, should we have a constitutional convention, and then calling a convention based on a majority of state citizens voting in favor of calling one, has never been used to amend the Constitution in Alaska, though that's not for a lack of opportunity. As the state constitution says, the state is required to ask its citizens every 10 years or so whether or not they want to call a convention by putting should we call a convention on the ballot. That's like kind of crazy. And even crazier is that Article 13, Section 4 of the state constitution also clarifies that constitutional convention shall have plenary power to amend or revise the Constitution, subject only to ratification by the people. No call for a constitutional convention shall limit these powers of the convention. In other words, if you call an Alaskan state constitutional convention, all bets are off. The delegates can propose as many amendments as they want about whatever topics they want. This again appears inspired by an unsettled issue regarding amending the federal constitution, which is whether or not a federal constitutional convention could legally be limited in its scope, or would have to be allowed to propose as many amendments about as many topics as it sees fit. In other words, it's not clear on the federal level whether state legislatures could vote to call a constitutional convention just about, say, whether to amend the Second Amendment, or whether the states are limited to calling a convention where delegates choose what amendments to propose. Anyway, it's fascinating to see this kind of design choice in a state constitution, one that makes amendment not just theoretically possible, but systematically available at regular intervals to state citizens. It's equally fascinating that despite the systemic availability and thus relative accessibility, Alaska state citizens have never chosen to utilize the option by calling for a state constitutional convention. I guess that's a testament to how satisfied Alaska citizens are to their form of government, though I'd wager that satisfaction doesn't always extend to the people who are in charge of that government. To be clear, if for some reason Alaska ever chose to take this route in the future and to call a state constitutional convention, the delegates at that convention, just like as if the legislature was proposing a state amendment, wouldn't be able to actually pass a state amendment by themselves. Instead, all that these Alaskan state constitutional conventions could do would be to vote on whether to propose amendments. And then these proposed amendments would be put to the people via ballot for them to vote on whether or not they should be adopted. Last thing before we move off Alaska for a warmer climate. While voting on the once every 10 years ballot measure is one way to call a state constitutional convention, the Alaska Constitution also indicates that the legislature itself can call a constitutional convention at any time. To my knowledge, this method has also never seen use, and the legislature instead has preferred to simply propose single amendments. Possibly because they know if they called a state constitutional convention, they might not be able to control what happened there. So that's Alaska. Let's move on to those hippies in California. It may seem like Californians have decided to join their Alaskan brethren by laying out all the state constitution amendment process info in a single section of their state constitution. And there is an article of the California Constitution entitled Amending and Revising the Constitution. But as we'll see, things are not as simple as they appear. Let's start with the easier stuff. Article 18, Section 1 of the California Constitution provides that, similar to Alaska, the state legislature can propose an amendment to the Constitution by a 2/3 vote of both houses. And Article 18, Section 4 says that any amendment proposed by the legislature, or by other methods we'll cover in a sec, goes to the people via ballot for them to vote on. Article 18, Section 2 says that the legislature can also do a 2/3 supermajority vote to call for a state constitutional convention. And if they vote for it, the question of whether to call a convention is put on the ballot for voters to consider. This is kind of like Alaska, but note that unlike Alaska, the convention question is not automatically put on the ballot every 10 years. The legislature also can't call a convention of its own accord. It can only vote to ask state citizens whether they want to call a convention. That leaves us with the last section of this article. Article 18, Section 3 of the California State Constitution says, the electors may amend the Constitution by initiative. Short and sweet. Easy peasy, right? Small question. What's an initiative? Oh boy. Here's where things get a little trickier. Article 18 doesn't define or even explain the initiative process in California. To learn more, we have to look at a completely different part of the state constitution, which is why we actually can't look at just one part of the state constitution to know how to amend it, despite there only being one article entitled Amending the Constitution. Alaska's drafters would never have allowed this kind of imprecision. That's all I'm saying. Anyway, the initiative process is set out in Article 2 of the California Constitution, which is entitled Voting, Initiative, and Referendum, and Recall. This is a long-ass part of the state constitution, and only some of it is relevant for our purposes, so I'll just be picking out the pieces we care about. Article 2, Section 1 should sound familiar at this point. Quote, all political power is inherent in the people, government is instituted for their protection, security, and benefit, and they have the right to alter or reform it when the public good may require. This is that common provision in a lot of state constitutions that recognizes the government's legitimacy flows from state citizens, and that consistent with this wellspring of authority, state citizens retain the right to modify their form of government in accordance with their preferences and values. Then we go ahead and scroll down to Article 2, Section 8, which is all about the power of the initiative, i.e. the thing that Article 18 says is one way that amendments to the state constitution can be proposed. Article 2, Section 8 defines the initiative as the power of the electors to propose statutes and amendments to the Constitution and to adopt or reject them, and then goes on to explain the process by which an initiative can begin. Quote, an initiative measure may be proposed by presenting to the Secretary of State a petition that sets forth the text of the proposed statute or amendment to the Constitution and is certified to have been signed by electors equal in number to 5% in the case of a statute and 8% in the case of an amendment to the state constitution of the votes for all candidates for governor at the last gubernatorial election. Now, quick sidebar here. 8% might not seem like a huge number. As we'll see in a second, you're eventually going to need to get more than 50% of the state to vote in favor of the amendment, assuming you get to propose it via initiative. But the difficulty this 8% requirement imposes should not be underestimated. First of all, at the time of writing, the 2020 census reflects that 78% of Californians are voting age. This means there are 30,853,425 potential electors running around in the Bear Republic. You thus could theoretically need somewhere in the neighborhood of 2.5 million signatures in order to get a state constitutional amendment in the door to start the initiative process. Now, crucially, Section 8 says that you only need 8% of the votes for, quote, all candidates for governor at the last gubernatorial election. Lots of people of voting age still choose not to vote, and plenty of people who do choose to vote may also just choose not to participate in the election for a governor. So taking a look at the last California gubernatorial election, where you all saw fit to vote for that motherfucker Gavin Newsom, I don't care who he's running against. I'm not going to vote for that guy for president in 2028. It looks like there were a total of 10,933,000 people in California who cast ballots in the 2022 gubernatorial election. So if you want to get an amendment on the ballot right now, you just need the paltry sum of 874,641 signatures. That's no big deal, right? Well, it gets even worse. As anyone who's ever tried to collect signatures for a political thing can tell you, there are about 10 million little procedural or other hurdles that a state or local government can throw at you to make climbing this mountain of a bajillion signatures even tougher. Anecdotally, I've heard it said that whenever you try to meet a signature requirement for a ballot measure or a political candidate or whatever, you should plan to actually get 3 times the number of nominally required signatures because 2/3 of them are probably going to be deemed insufficiently legible or otherwise not count. You can see how this creates a pretty burdensome process. And to be clear, these need to be handwritten signatures. This is not a change.com online petition or whatever. Somebody has to actually schlep out in meet space and talk to people and convince them to give their signature. There is no easy, practical way to do this for the millions of people you need to sign your initiative for a constitutional amendment in California, unless you have a dedicated team, financial resources to fund that team, probably some lawyers to help push back if the content of the proposed amendment is unpopular with the state government and they try to find little procedural ways to kill it, etc. As a result, in practice, well-heeled corporate and political organizations are generally the ones who have the most success capturing the proposed amendment by initiative process, and indeed the power of the initiative as a whole in California and elsewhere. Not all things that end up on state ballots are there just because they're the brainchild of some deep-pocketed political party or corporation. No, not all, just most. Anyway, back to Article 2 of the California State Constitution. As just discussed, a ballot measure can be proposed via initiative by first presenting a petition signed by a number of voters equal to 8% of the number that voted in the past gubernatorial election. Suppose someone wanting a localist amendment manages to actually get the required number of signatures. What then? Well, it gets put on the ballot, and if a majority of voters support it, then the state constitutional amendment passes. Nothing we haven't seen before. But there are still 1 or 2 more wrinkles to bring up. First, usually the way that this works is that the amendment proposed via initiative just gets stuck on the ballot during the next election. But under Article 2, Section 8 of the California Constitution, the governor may also call a special statewide election for the measure. This actually gives the party that controls the governorship a pretty large degree of sway over how likely a proposed amendment is to pass once it's put to a statewide ballot. For example, a governor could choose to call a special election immediately if the governor wants the amendment not to pass and believes that a quick vote will result in the amendment being defeated. So if you're pushing for a localist amendment in California, you need to keep in mind that the governor could choose to undercut you by scheduling you for a quick election, or alternatively by choosing not to order a special election and putting his political spin doctors to work until the next regular election. Second, California has an interesting provision that explains what happens when 2 proposed amendments both receive more than 50% of cast votes at the statewide ballot step, but the 2 proposed amendments that pass are in conflict. This could look like a proposed localist amendment getting 55% of all votes that are cast on it being yes, but in the same election, a proposed amendment that would strip away all home rule powers from California localities gets 53% of all votes cast for it being yes. These can't both be implemented. So which one ends up being passed? Well, under Article 2, Section 10, quote, if provisions of 2 or more measures approved at the same election conflict, the provisions of the measure receiving the highest number of affirmative votes shall prevail. Note that this says highest number, not highest percentage. So in the hypothetical I just raised, even though the localist amendment got 55% yes votes and the kill home rule amendment might only get 53% yes votes, if it turns out that 1 million people voted yes on the localist amendment and 1.1 million people voted yes on the kill home rule amendment, the kill home rule amendment is still the one that wins. One last thing about California. This isn't in the state constitution, it's instead provided by state law or other legal sources. But there's actually a step you need to take before you can even start collecting the required signatures to get a constitutional amendment on the ballot. This preparatory step is to write the initial text of your proposed law and send it to the state attorney general for an official title and summary. You also have to cough up a $2,000 filing fee that only gets refunded if the AG gives you the okay to start collecting signatures for your proposed amendment. There's also a bunch of really strict deadline and certification and other requirements, and that petition you send to the AG needs to be signed by 25 other people, and the petition you ultimately use to try and gather signatures to get the amendment on a ballot has a specific format required by law, and etc., etc., etc. The state attorney general has a whole 40-page document about the hoops and processes that you need to jump through in order to get a referendum on the ballot about a state constitutional amendment. And this 40-page document is so detailed, it even has specific font regulations for what your petition needs to look like. Make sure your reprinting of the Attorney General's summary is in 11-point or larger Roman type. Seriously, there's like a million different little things that you have to get right, any one of which could potentially sink your chances of getting to propose an amendment and getting that proposed amendment actually on the ballot. No wonder the only people who generally can make the initiative process work are big corporations or political parties with the cash to hire specialized attorneys to advise them on this whole process. With this complaining about California out of the way, let's now talk about the Texas state constitution. Since everything is bigger in Texas, does Texas make amending a constitution an equally enormous pain in the ass? Hard to imagine anything being a bigger pain in the ass than California's initiative requirements, but let's take a look. As it turns out, no, Texas does not have a big complicated process for amending the state constitution. But that's because it has the fewest avenues by which to amend the state constitution of any of the states we'll discuss today. The relevant provision of the Texas state constitution is mercifully short. Article 17 is helpfully titled Mode of Amending the Constitution of the State. That's mode singular, as we'll see. There's only really two pieces of text we care about here, so I'm just going to read them to you verbatim. Quote, "The legislature, at any regular session or at any special session when the matter is included within the purposes for which the session is convened, may propose amendments revising the Constitution to be voted upon by the qualified voters for statewide offices and propositions as defined in the Constitution and statutes of the state. The date of the election shall be specified by the legislature. The proposal for submission must be approved by a vote of 2/3 of all the members elected to each house." And the second bit of text we care about, quote, "The election shall be held in accordance with procedures prescribed by the legislature, and the returning officer in each county shall make returns to the Secretary of State of the number of legal votes cast at the election for and against each amendment. If it appears from the returns that a majority of the votes have been cast in favor of the amendment, it shall become part of this Constitution." And yeah, there you go. There's a couple other things in Article 17, but we don't have to worry about those. Under the Texas state constitution, the way to amend the Constitution, the way singular, is to have 2/3 of each house of the state legislature propose the amendment, then have the people of the state vote on whether they want it to pass. Very simple, very straightforward. Now let me preface the bunch of complaining I'm about to do by saying I actually really like simplicity. I like it when average people don't have to wade through 40 fucking pages of shit just to understand what font size you need to do an amendment initiative petition or whatever the fuck. So I can appreciate that part of the Texas method for amending the state constitution. But you know what I don't appreciate? That Texas's state constitution takes any power to propose amendments out of the hands of regular people. There's no way to propose an amendment via an initiative in Texas. Nor is there any requirement to put a should we have a constitutional convention question on the ballot every 10 or 20 years. And indeed, there is no provision for amendment via convention at all in the Texas state constitution. In other words, the state legislature has preserved for itself the total power to be the gatekeepers of amendments to the state constitution. Without support and instigation from the state legislature, no amendment will ever pass. And I really hate that. A bunch of state politicians should not exercise the exclusive right to propose amendments to the state constitution. The people should have that power too, if they so wish, propose changes to their form of government. As it stands, the only ones who can do that in Texas are the compromised, partisan, career politicians in the state legislature. It's literally the definition of top-down rule. Sure, the people still get to vote on whether to pass any particular amendment that may emanate out of the legislature. That does provide something of a check, I guess you could say. But when it comes to a matter as fundamental as your state's form of government, your state's constitution, state citizens should have more than just a check. They should have the right to serve as both author and decider of amendments. Fuck, California's shit-ass, finicky, and overly regulated initiative system might suck a lot, but at least it's there. At least it gives ordinary people a possible path towards proposing important changes to their state constitution. And both California and Alaska provide this other path of calling a state constitutional convention. If you live in Texas, you're not so lucky. You don't even get a way to call a state constitutional convention, and you definitely don't have an initiative power. It's only elected state politicians, only people thoroughly embedded in party politics and who are disconnected from the people they serve financially and socially who get to propose amendments. Texas's failure to provide for any non-legislature way to amend the state constitution is particularly glaring when you look at another part of the state constitution. More specifically, a part of the state constitution that has language that should be pretty familiar to us by now. Article 1, Section 2 of the Texas State Constitution says, quote, all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. The faith of the people of Texas stands pledged to the preservation of a republican form of government, and, subject to this limitation only, they have at all times an inalienable right to alter, reform, or abolish their government in such a manner as they may think expedient. Interesting to note the very explicit invocation of small r republican government, perhaps trying to dodge guarantee clause concerns. For a very extended discussion of the guarantee clause, please check out our early episode about whether direct democracy is constitutional in America. But that small quirk aside, the Texas state constitution directly acknowledges that the Texas state government gets its legitimacy from the people, and the people therefore have the right to alter their form of government. Funny how the Constitution then proceeds to take a major chunk of that right, the right to alter your form of government by state constitutional amendment, out of the hands of ordinary citizens and reserves it solely for a bunch of party politicians in the state capitol. Guess that right to alter or reform the government isn't so inalienable after all, huh? With my regularly scheduled shit-talking of Texas out of the way, let's move on to the final state constitution we'll be discussing today, New York's. Now, I'll be honest, coming into this, I expected that New York's process for amending a state constitution was going to be very similar to California's. Complicated, all over the place, a bunch of finicky requirements, maybe an initiative process. After all, these are two big liberal states dominated by liberal urban interests. You might assume that they approach this question pretty similarly. But, as it turns out, that's not true at all. Let's jump in. First things first, let's deviate for a quick little sidebar. Remember how I clowned Texas for having a state constitutional provision about fucking bingo? Well, guess what? New York has a provision about bingo too. Article 1, Section 9 of the New York State Constitution provides that only charitable or religious organizations can hold bingos, and even says the prizes can't add up to more than $1,000. Nothing more classic. We see this all the time than, let me just check my notes here real quick, New York and Texas agreeing on what needs to be in state constitutions? Anyway, back to the amending the state constitution stuff. Let's check for that now standard provision in a lot of these state constitutions that explains government emanates from the people, and therefore they have the right to change their form of government. This has, in one form or another, been in each of the state constitutions we've talked about so far today. Well, I gave the New York State Constitution my best look over, and to my surprise, I didn't find this common government power comes from the people acknowledgement. It doesn't seem to be present. Very weird. I truly have no idea why New York's Constitution would lack this provision, especially because it seems like it sets out a bedrock principle of American governance and is present in all these other state constitutions. I thought, okay, maybe it's a regional thing, and East Coast states or the states made from the original 13 colonies just don't have this provision. So I took a peek at the Rhode Island and Massachusetts and Virginia state constitutions, and it's interesting. None of these state constitutions have, literally copy-paste the same provision that we see in states like Alaska, California, Texas, etc., but they do all have some provision that at least expresses the same or a similar idea, that political power flows from the people. Massachusetts has Part the First, Article 7, quote, government is instituted for the common good, for the protection, safety, prosperity, and happiness of the people, and not for the profit, honor, or private interest of any one man, family, or class of men. Therefore, the people alone have an incontestable, unalienable, and indefeasible right to institute government and to perform, alter, or totally change the same when the protection, safety, prosperity, and happiness require it. Rhode Island's state constitution has Article 1, Section 1, quote, in the words of the father of his country, we declare that the basis of our political systems is the right of the people to make and alter their constitutions of government, but that the constitution which at any time exists, till changed by an explicit and authentic act of the whole people, is sacredly obligatory upon all. And then there's Virginia's constitution. Article 1, Section 2 says, quote, that all power is vested in and consequently derived from the people, that magistrates are their trustees and servants, and at all times amenable to them. So my amateur opinion is that New York really is an outlier to not have anything in its state constitution that acknowledges that political power flows from the people. I don't know why this is the case. If you're a New York state constitutional expert, please get in touch. What's not weird is the general process for amending the state constitution, aside from this kind of recognition where the state's political legitimacy comes from. Article 19, entitled Amending the Constitution, has all the info that we need on how to amend the New York State Constitution. Article 19, Section 1 tells us that one way amendments can be proposed is to have them introduced in the state legislature and pass both houses. Once the proposed amendment passes, it's then placed on the ballot for state citizens to either approve or reject. We've heard this story time and time again with the other states. The state legislature gets to propose an amendment, but then it's up to the people to decide whether or not to approve it and actually make it part of the state constitution. But there is an interesting New York-specific point here. Unlike the other states we've discussed, the New York State Constitution does not require a supermajority in each house of the state legislature to put an amendment on the ballot for the people to consider, and need only be, quote, agreed to by a majority of all the members elected to each house. That means the political barriers to getting an amendment on the ballot via the legislature are much lower in New York than they might be in other states. It's a hell of a lot easier to get 51% of state politicians to agree than it is to convince 66% of state politicians to agree. Given how politics currently works, the mere majority requirement basically means whatever party happens to control the state government will also have essentially free reign to propose amendments to the people. Okay, so that's the first option for amending the New York State Constitution. The second option is by constitutional convention, and the way of calling that convention is very similar to the way set out in the Alaska Constitution. Under Article 19, Section 2 of the New York State Constitution, every 20 years, the state needs to put the question, should we have a constitutional convention, on the ballot. If a majority of people vote yes, then the next step is to elect delegates, and these delegates can then go on to propose an amendment via a simple majority vote of the other delegates at the convention. The proposed amendment or amendments then go to the ballot for state citizens to vote on. Like I said, very similar to Alaska. And also like Alaska, to my knowledge, New York has never actually voted to hold a constitutional convention in this manner. One final quirk about New York's processes for amending its state constitution. New York's constitution has a section addressing a rare but conceivable scenario that could arise when trying to amend the constitution. Suppose that the state legislature submits a constitutional amendment that, makes it so people who wear a blue shirt for 200 days out of the year get a state tax refund of $20. But the legislature happens to submit this amendment at the same time that a state constitutional convention is going on. And the state constitutional convention instead submits a proposed amendment that says people who wear a blue-collared shirt for 200 days out of the year will actually have a $20 penalty added to their tax bill. Which amendment gets put on the ballot? If they both do and both pass, which one actually becomes part of the state constitution? Article 19, Section 3 answers this question in a manner that, to my mind, actually creates a bunch more questions. Quote, any amendment proposed by a constitutional convention relating to the same subject as an amendment proposed by the legislature, coincidentally submitted to the people for approval, shall, if approved, be deemed to supersede the amendment so proposed by the legislature. So, okay, on its surface, this just means that in my little example, the amendment from the state constitutional convention will win out over the amendment proposed by the state legislature, assuming that voters vote to pass both. So if voters vote to pass both the state legislature's amendment that you get $20 on your tax rebate if you wear a blue shirt for a bunch of the year, that amendment isn't going to pass, and instead it's going to be superseded by the state constitutional convention's proposed amendment, which was if you wear a blue shirt a bunch during the year, you're going to have to pay the state $20. Sure, that example is pretty straightforward, but there's a point or two of strangeness in the wording of Article 19, Section 3 that the example doesn't answer for us. For one, what does coincidentally submitted mean? Remember that Article 19, Section 3 says any amendment proposed by a constitutional convention relating to the same subject as an amendment proposed by the legislature coincidentally submitted to the people. Does that mean that if it isn't a coincidence that two proposed state constitutional amendments conflict, maybe the state constitutional convention deliberately proposes a contradictory amendment to something that the legislature has put forward, then Article 19, Section 3 doesn't apply? It has to be an accident that there's this conflict between two simultaneously proposed amendments? And what does the relating to the same subject language mean? That is specifically any amendment proposed by a constitutional convention relating to the same subject as an amendment proposed by the legislature. Does this mean there needs to be a contradiction between the two proposals, like in the example I gave about blue shirts? Or does related to literally mean related to, as in the two amendments are just about the same thing? So to change my past example a little bit, suppose the state legislature is proposing a $20 tax rebate for people who wear a blue shirt 200 days out of the year, and suppose the constitutional convention puts forward a proposed amendment at the same time that people who wear a blue shirt 200 days out of the year get a New York branded Blue Shirt Club sticker sent to them by the state. Technically, these proposed amendments don't conflict. If both pass, you could just get the rebate plus a sticker for wearing your blue shirt a lot. But they are both related to a reward you get for wearing a blue shirt. Does that mean that the Constitutional Convention sticker proposal supersedes the legislature's tax rebate proposal despite the lack of contradiction? To be clear, given that New York has never called a state constitutional convention, these questions are all very academic. They're what-if scenarios wrapped up within other what-if scenarios. But to a big nerd like me, it's this kind of stuff that really gets me going. Again, if there happens to be anyone listening who's an expert on New York State constitutional law, please shoot me an email and tell me if you know the answers to how Article 19, Section 3 is interpreted. And before we conclude our conversation on state constitutions, a final observation. How much flexibility and control a state constitution gives state citizens regarding amendments doesn't really track the traditional political boundaries that we think of today. That's how we can end up in situations where Alaska and Texas, despite both being conservative strongholds, have very different approaches to amending the Constitution. And Alaska and New York, despite being firmly at odds in pretty much every respect politically, can actually have a pretty similar approach to amending state constitutions. This is a reminder of something that I've really tried to highlight and emphasize across the course of this podcast, that questions about the scope of local authority, individual political agency, democracy, form of government, justice, and indeed, localism, really are not a left versus right thing. It's a different spectrum, a different set of poles that instead ask more fundamental questions about our conception of legitimate government and accountability. Because of this, it's my genuine and fervent belief that localism and other reform efforts to increase local authority and increase individual political agency truly represent a large tent, a movement where people who disagree with each other adamantly on almost everything politically can nevertheless set aside their differences and work together to achieve greater local autonomy and individual agency in America. And with that little note, that was my crash course on how to amend state constitutions. Like I said, this isn't even 10% of all the state constitutions in America, and I won't really be able to give you a full account of how things work in your state, unless you happen to live in Alaska, California, Texas, or New York, in which case I can give you a partial account of how things work in your state. But hopefully this little sample, this little introduction of constitutions for both conservative and liberal states will serve as a useful generalized primer on what I think is truly one of the most fascinating areas of American law and American political life. And hey, if you live in a place that isn't the 4 states that we discussed today and are curious about your state constitution, feel free to send me an email. I'm not a lawyer and I can't guarantee that the information I give you will be 100% accurate, but I'm at least happy to give your state constitution a quick read and share my take on how the amendment process seems to work in your state. To finish everything up here, remember, no matter whether your community is interested in the absolute or reformist model of localism, you are definitely going to need to amend the state constitution. So all this stuff isn't just a thought exercise. If you're interested in making localism a reality, you need to carefully review your state's amendment process and consider how that process will play out politically if you want to pass the amendments that are needed to make localism a reality. Next time, state constitutional amendments will cut it when it comes to the reformist model of localism, and they have their place in the absolute model too. But the absolute model also requires amendments of a very different sort. To turn the pyramid of preemption fully upside down, you'll need to do one of the most difficult political tasks possible in America: pass a federal constitutional amendment. And in the next episode, that's exactly what I'll teach you how to do. If that sounds interesting, be sure to catch the next episode on Spotify or on YouTube, and feel free to drop me a question or comment at localistpod@gmail.com. That's localist with a T, pod@gmail.com, and I'll see you all in the next episode. A huge thank you to Kevin MacLeod for letting me use the 2 songs in this podcast, Acid Jazz and Opportunity Walks. You can find these and a bunch of other really great songs on Kevin's website, incompetech.com. And the use of Kevin's music here is licensed under Creative Commons by Attribution 4.0.